Hello, my name is Jeff Vogt. I'm the legal director of the Solidarity Center and founder of the ILO network. The ILO network is a global network of worker rights and trade union lawyers around the world, including in Korea. And I'm a member of the ILO Committee on Freedom of Association. I'm one of the worker members to the committee. Thank you very much for inviting me to talk to you today about the case, most recent case from Korea concerning from the Committee on Freedom of Association, case number 3430, concerning collective bargaining guidelines in the public sector. And I'm just going to share my screen. So some basic information about the case. It was filed by the Korean Public Services and Transport Workers Union, KPTU, KCTU, the Korean Confederation of Trade Unions, and Public Services International last June 2022. And the committee took up the case in June of this year. And it's in a follow-up status, meaning that the case remains open for further examination. And the link to the case is below with that link below. So I'm going to just go over the basic allegations that are in the case. So the petitioners collectively raised concerns around the fact that the government has unilaterally issued a number of guidelines, 3 guidelines in particular, concerning matters that are normally covered by collective bargaining between public employers and unions, that the government then used, penalized public employers that failed to comply with these guidelines by reducing points through a management scheme, through management evaluations, and this management evaluation scheme then would determine bonuses for those public entities. This is something that is wide-ranging. There are over 350 institutions that are considered public institutions. So this is not only affecting the civil service. It has a broad implication for the Korean labor market. The more specific allegations are here. One is that the government in 2022 passed budget guidelines that limit the increase in each public institution's total labor cost to 1.4% of the figure the year before. That management guidelines that were introduced in 2021 require all public institutions to adopt wage peaks. Another issue had to do with the fact that the budget guidelines also provided and were changed in 2022 so that when workers had successful lawsuits against the public institutions for failure to pay proper wages and overtime, that instead of this payments coming out of a reserve fund, which was the practice, that these payments came out of the actual annual labor budget, which then obviously created disincentives for workers to pursue these claims, because then it would penalize them by reducing the amount available to pay salaries in the following year. The complaint also noted the unilateral elimination of a previous seniority-based wage system and replacing it with a performance-based wage system. Also in 2021 were innovation guidelines that required public institutions to have a tighter control over in-company loans to employees. And as I mentioned earlier, these guidelines were effectively enforced through performance evaluations. So the government argues that, well, these are merely guidelines, they're not mandatory, but in fact, by using these performance evaluations, they could score managers low if they exceeded, for example, the 1.4 percentage increase. And in fact, the information presented by the petitioners show that nearly every public institution limited the wage increase to 1.4% or below. There were only 2 or 3 institutions that did not follow the guidelines on the annual wage increase. So they were effectively mandatory guidelines that again were enforced by the performance evaluations. And finally, the petitioners note that there is an absence of channels of direct negotiation and communication between the unions and the government, and that the government is essentially hiding behind the nominal heads and boards of these public institutions. And there's no way for unions just simply to negotiate with the government, and instead using these 350 different institutions to create 350 different points for a collective negotiation. So those were the basic allegations that were set forth in the complaint to the Committee on Freedom of Association. And so the CFA came up with a number of conclusions and recommendations. And with regarding public sector collective bargaining, the committee has stated in the past, and it's here, but I'll read it and explain it. It says, in view of the special characteristics of most public institutions, a framework may be defined for the exercise of the right to collective bargaining in those institutions, with a view to ensuring the preservation of public interest. So this is to say that this is unlike the private sector. The assets, the resources of the public sector obviously largely come from taxation. There's a finite amount of resources, and so that it is permissible for there to be a general framework in which collective bargaining takes place in order to safeguard the resources of the public. However, that doesn't mean that there cannot be collective bargaining. It just needs to take place within a broad framework. And so the rest of the quote here is, nevertheless, committee also considers that, as in previous cases, including previous cases concerning Korea, to be compatible with the right to free and voluntary collective bargaining, this framework should leave significant role to collective bargaining, and that it is essential that workers and their organizations be able to participate fully and meaningfully in designing that overall bargaining framework, which implies in particular that they must have access to all financial, budgetary, and other data enabling them to assess the situation. So this is to say that these guidelines, which the government introduced unilaterally, should have themselves been the subject of negotiation, right? That and try to come up with any framework in which collective bargaining needs to take place itself must be bargained, right? So that it would, and so therefore, any of these guidelines which affect the scope of collective bargaining that were imposed directly by the government without consultation, without negotiation, are therefore run contrary to principles of freedom of association. And then within that framework, then collective bargaining must also be able to take place. So the committee made a number of findings. I'm not going to go through all of them here, but I'll note a few. So with regard to the issue of total labor costs, the committee found every year the workers in public institutions subject to the guidelines and their organizations have been denied participation in designing the framework governing collective bargaining on wage increases and total labor cost control. With regard to the issue of wage lawsuits, the committee observes that there would appear to be no role for autonomous management labor agreements in relation to the source of payment and the impact that this may have globally on working conditions. And regarding the performance and incentive bonuses, the committee notes that the budget guidelines, which the government confirms are drawn up without the participation of workers' organizations, set the general rule of differential distribution. So again, there are a number of conclusions in this, but just to again show that the committee, sorry, the committee has found that the allegations by the petitioners were generally supported, and that they were violating principles of voluntary collective bargaining. So this is really the ultimate finding of the committee in the case. The committee notes that the standards set in the government guidelines in relation to the issues raised in the complaint indeed constitute a framework that in several respects limits the content of collective bargaining at the individual institution level, although collective bargaining maintains a role in many aspects relating to the determination of the modalities of implementation of the general principles formulated in centrally issued recommendations. The committee expresses its concern that the combined effect of many of the recent recommendations limits the effective space for collective bargaining and does so on the basis of guidelines over which there has been no recent consultation or participation. So this is essentially the finding in this case, and the recommendation by the committee, which again is essentially what the committee is therefore requesting the government do based on the review of the facts and its conclusions. The committee requests the government to establish a regular consultation mechanism. So again, when coming up with any framework for collective bargaining in the public sector, there now needs to be a consultation mechanism between the government and the trade unions that would allow the full and meaningful participation of organizations representing workers in public institutions in the formulation on the matters raised in the complaint, so as to ensure that the guidelines issued at the central level do not effectively interfere with collective bargaining. And again, the case goes through each of the allegations and notes where the guidelines on its face or as they are applied limit the scope for collective bargaining, and also noting that these various guidelines and policy decisions were not taken in consultation with unions, so that these guidelines do not effectively interfere with collective bargaining in the public institution, and that the committee requests the government to keep it informed of the measures taken in this regard. So in concluding, some final considerations, we know that this is a repeated problem in Korea. We have seen this addressed in cases 2829 and 3237, where similar allegations have been raised. Now we have it a third time. So it'll be really important for the petitioners to update the committee as to whether a regular mechanism has been created, whether the unions are involved in the negotiation of those guidelines, whether these guidelines allow for collective bargaining, and then to report on the results of that bargaining. So I think those four issues will be important to get further information on, obviously from the government, but also importantly from the petitioners, so we can evaluate the information that is provided to us. And then, they can consider if there is, the petitioners could consider if there is no progress being made, and the fact that this is a repeated problem, perhaps to invite the ILO to do what's called a direct contact mission, to invite the ILO to discuss public sector collective bargaining, and perhaps provide some technical assistance on how to create a system or framework in the public sector that will allow for space for voluntary collective bargaining. So thank you very much for the invitation to present this case to you, and good luck with your deliberations, and I'll be happy to receive any questions by email through the organizers of this event if you have any. Thank you very much. Bye-bye.